Right at the outset, legal practitioners are entrusted to make a decision as to how to approach court, by way of action or application. So how do you choose? An application would be when the facts are mostly common cause and the dispute would be a legal dispute. In applications, your evidence is presented on paper, on affidavit, whereas in an action, the evidence is verbal and subject to cross-examination. It's a very important decision to make, because that decision could ultimately determine whether your case is going to be successful or not. Now, when it comes to an application, the basics are that you would have a notice of motion and you would have a founding affidavit. Your relief will be contained in your notice of motion, which will also contain certain time limits relating to the filing of opposition, answering papers, replying papers, etc. The most important facet is that your affidavit needs to support the relief that you're seeking in your notice of motion. So besides the fact that you need to establish, firstly, that the applicant has locus standi and the authority to depose to the affidavit if it's not the applicant, him or herself, you have to establish jurisdiction, your cause of action, and the relief that you're seeking. So if you are seeking interdictory relief in your notice of motion, then you need to make out a case for that interdictory relief in your founding papers. So an example of matters that could be brought by application would be evictions, interdicts, requests for information. So once you have filed your application, the respondent then has an opportunity to file an answering affidavit. Now, as I said to you earlier, applicant is supposed to approach court by way of application when there is not a dispute of fact. So what happens if the respondent raises a dispute of fact? And when is that raised? It's raised when the respondent demonstrates to the court, honestly and seriously, that there are facts which demonstrate such dispute. What will the court do? Well, if we have a look at Rule 65G, a court can dismiss the application outright, or it can be referred to oral evidence in certain circumstances, or you may have heard of the Plaskon-Evans rule. And the Plaskon-Evans rule permits the court to give relief even if there is a genuine dispute of fact. The test is described as follows. When the averments of the respondent, taken in conjunction with the admitted facts of the applicant, applicant's case justify an order, then the court may make such an order. But if the respondent's case is so untenable or unbelievable, then the court may decline to make such a finding. The applicant also could still have a finding in its favour, should the court believe in the inherent credibility of the facts in the applicant's finding affidavit. So the message today is, think long and hard before you choose the procedure that you're going to adopt when approaching court. Consider the facts that you're going to put before the court and the nature of your case. We will continue next time with the infamous urgent application. I hope you'll join me on Adjourn for Tea. It's been such a pleasure to share this pause with you today. Remember, your voice matters. So don't forget to like, subscribe, and tap the bell for the next tea adjournment.